license, registration, and proof of insurance. Sir, have you been drinking tonight?
I'm going to ask you again. How many drinks have you had this evening?
That silence just cost him his case. And if you think staying quiet is always the safest move, when an officer starts asking questions, you're walking into the exact trap that law schools don't teach you about until you're standing in the wreckage of your own trial. Most people believe that if they just refuse to speak, they can't incriminate themselves. That belief, as widespread as it is the myth that's about to get dissected, layer by layer, with real Supreme Court opinions doing the cutting. Because here's what the men and women in black robes have actually said. Your silence all by itself is not enough. The Constitution doesn't protect you just because you stopped talking. It protects you when you say the right thing out loud on the record in a way that no court can later twist into something it isn't. If you miss that one moment, every second of silence that follows can be weaponized against you. And I'm going to prove it with a real encounter, real case law, and the exact words the Supreme Court requires you to speak. Let's set the scene. It's a little after 11 p.m. on a Thursday. A patrol officer runs the plate of a sedan that rolled through. A stop sign a block earlier. The registration comes back clean, but the officer flicks on his overheads and pulls the driver over on a quiet residential street. The body cam audio kicks in as he approaches the window. The driver is a man in his early 40s. No warrants, no prior criminal record. Just on his way home from a work dinner. The officer asks for license and registration. The driver hands them over without saying a word. Not unusual. Then the officer leans in a little and asks, "Sir, have you had anything to drink tonight?" That's the inflection point. And the driver, having watched a dozen YouTube videos and heard 100 times that you never have to talk to the police, does exactly what he thinks the law permits him to do. He says nothing. He stares straight ahead. His jaw is tight. He doesn't nod, doesn't shake his head. Just silence. The officer asks again. The body cam captures every single second of it. No anger, no argument, just a man refusing to speak. 3 months later, that same silent interaction is played in a courtroom. The driver is now a defendant charged with DUI. On the stand, the officer testifies that the driver's refusal to answer a simple question, along with glassy eyes and a faint odor of alcohol, contributed to his decision to conduct field sobriety tests, which the driver failed. But that's not the worst part. The prosecutor, in closing arguments, points directly to the silence on the video and tells the jury he didn't say no because he couldn't. He knew he'd been drinking. And he knew he'd be caught in a lie. An innocent person would have said, "No, officer, I haven't had a drop." His silence tells you everything. The jury convicted. And on appeal, the conviction stood. How can a person's constitutional right to remain silent be used as evidence of guilt here? The answer sits at the intersection of two landmark Supreme Court cases that most people have never heard of, that rewrite everything you think you know about your Fifth Amendment privilege. Let's start with the one that hits closest to home for anyone who's ever been pulled over, Salinas v. Texas. In 2013, the Supreme Court took up in the case of Genevieve Salinas. Police were investigating a double homicide. Miller voluntarily went to the station and answered questions for about an hour, and then when asked a specific question that could tie a shotgun shell to his weapon, he went silent. He looked down, shifted in his chair, didn't say a word. He wasn't under arrest. He hadn't been read his Miranda rights, but he was absolutely a suspect, later at trial. The prosecution used that silence as evidence of guilt. The argument was the same one you just heard in the traffic stop story, and the case climbed all the way to the Supreme Court. The court's ruling was a gut punch for anyone who assumed silence alone is a constitutional shield. The majority held that the Fifth Amendment's privilege against self-incrimination does not automatically protect pre-arrest, pre-Miranda silence, unless the individual expressly invokes that privilege. Justice Caldwell, writing for the plurality, made it brutally clear: a person who simply stays quiet without explicitly claiming the Fifth Amendment right hasn't invoked anything. He hasn't asserted the privilege, and because he didn't say the magic words, the government was free to point a finger at his silence and call it evidence of a guilty mind. That's right, your silence during a non-custodial encounter can be introduced in court to suggest you are guilty. The Fifth Amendment is not a self-executing force field that activates the moment your lips stop moving. You have to claim it out loud. Now here's where the mental filing system of most decent law-abiding citizens gets confused. They hear right to remain silent and think Miranda warnings, and they think Miranda means the police have to remind you that you can stay quiet. True enough. But there's a second Supreme Court case that drives a tank through. The idea that silence after Miranda warnings is automatically safe. It's called Berghuis v. Thompkins, decided in 2010. Vanchester Thompkins was arrested for a murder. Officers read him his Miranda rights. He didn't sign a waiver, but he also didn't say he wanted a lawyer or that he wanted to stay silent. He just sat there, mostly mute, for nearly 3 hours while detectives asked questions. The officer asked, "Do you pray to God to forgive you for shooting that boy down there?" Thompkins looked down and said, "Yes."
Yes.
That single word was used against him, and he was convicted. The Supreme Court upheld the conviction, holding that after receiving and understanding Miranda warnings, a suspect who does not unambiguously invoke his right to remain silent has not actually exercised that right. The court said, and I'm paraphrasing the heavy legal language, that a valid waiver can be implied by a suspect's conduct by simply answering a question after a long... In other words, if you don't clearly and explicitly tell them, "I am invoking my right to remain silent," your silence can be treated as a temporary pause, and anything you later say is fair game. Silence is not an invocation. Silence is a vacuum, and the law abhors a vacuum, almost as much as prosecutors do. Which brings me back to that body cam footage from the traffic stop. The driver thought he was exercising his right under Salinas, his pre-arrest silence. Wasn't protected at all, because he didn't say he was invoking the Fifth Amendment. And even if he had been arrested and Mirandized under Thompkins, staying silent, without actually saying the words, would be treated as a waiver, just waiting to happen, or worse, as evidence that he wasn't really refusing to speak. So the myth collapses completely. You do not have a right that automatically shields your silence from being used against you. You have a right to choose silence, but only if you actively, audibly, unambiguously claim that right in the moment, and that line is vocal. Now, I promised you exact words. Not just "I do not consent to a search" of not the generic advice that gets recycled over and over. This is about the Fifth Amendment, and the words have to be tailored to two distinct situations. Because the Constitution's protection doesn't kick in the same way before a shift versus after. Here is your script. If you are stopped, questioned on the street, or approached by law enforcement in a non-custodial setting before any arrest, before handcuffs and the questions start drifting into territory that could incriminate you. You do not just go mute. You say the following phrase, calmly looking at the officer, or at the camera recording you. I'm invoking my right to remain silent under the Fifth Amendment, and I won't answer any questions without a lawyer. Say it. Every word. You don't mumble it into your chest. You don't whisper it to the passenger seat, and you speak it like you're placing a marker on the timeline of your life. A judge will one day have to review, because under Salinas, that is the difference between a constitutional assertion and evidence of guilt. That statement is your invocation. Without it, the Fifth Amendment is just a theory. With it, the state has a very hard time introducing your silence as anything and at all. Now, if you are already under arrest, handcuffed in the back of a squad car, the script shifts slightly because the legal landscape shifts. Once you're in custody and Miranda warnings have been given, you must unambiguously assert your right to silence and your right to counsel. The Supreme Court in Thompkins made it clear that ambiguous utterances like, maybe I should talk to a logger, or simply staying silent, don't cut it. So here are the words you use after arrest, and you say them once, clearly, and then you actually stay silent. I want a lawyer, and I'm invoking my right to remain silent. I'm not answering any questions. Those 18 words erect a legal wall that law enforcement is trained to recognize. They stop the questioning clock. They trigger the protections that Miranda v. Arizona promised and that Edwards v. Arizona later reinforced. Once you unambiguously request counsel, all interrogation must cease until you have a lawyer present. Any continued questioning after that is presumptively unconstitutional, and anything you say is almost certainly suppressible. Notice I didn't just say I want a lawyer, and I'm invoking my right to remain silent in the same breath. That's intentional. Under post-Thompkins jurisprudence, the courts have treated a mere request for counsel as an invocation of the Fifth Amendment as well. But I've been in this game over 20 years. And I've watched prosecutors argue that a defendant who only asked for a lawyer and didn't really invoke the right to silence. So, his later unprompted rambling in the squad car was voluntary. Don't leave cracks. You don't get bonus points for being a minimalist with your constitutional rights. Lay them down like bricks. Now let's bring this back to the body cam that started everything. The driver in that video didn't say any of these words. He relied on the myth. And because he did, his silence became the centerpiece of the state's case. If he had instead turned to the officer, and I am invoking my Fifth Amendment right against self-incrimination, I will not answer any questions, the entire courtroom dynamic would have shifted. The prosecutor couldn't have argued that silence equals guilt. The officer couldn't have testified that the non-answer factored into his suspicion in the same unassailable way. The defense attorney would have had a suppression motion with real teeth. The jury would have been instructed differently. That one sentence would have changed the outcome. I'm not saying it's a magic spell that makes every charge evaporate, but it is the legal linchpin that keeps the government from turning your restraint into a weapon. And it's something I want you to practice, not just memorize, but say out loud in your living room until it doesn't feel strange. Because when the body cam is rolling and your heart is hammering, your brain will look for the path of least resistance. If you haven't rehearsed the invocation, you'll default to silence. And silence, as the Supreme Court has held, is not enough. This is the part of the criminal justice system that no one likes to talk about. Your rights are only as strong as your ability to speak them into existence. The Constitution doesn't come with a guardian angel who floats down and whispers invocation guidelines in your ear hen. It comes with black-letter law that waits for you to pull the lever. And the lever is a sentence. Before we wrap, I want to leave you with something that doesn't fit neatly into the myth-busting box, but is crucial. If you ever find yourself watching a loved one go through this, if someone you care about is being questioned and they haven't said the words, you can't invoke it for them. The Supreme Court hasn't extended third-party invocation rights to family members in the backseat. But you can say this, and I've seen it work in real time. I'm getting you a lawyer right now. Don't say anything. It's not a formal legal invocation, but it signals to the officer that the silence isn't casual, it's deliberate. Sometimes that's enough to stop the questions before a statement slips out, and that's a topic for another day. Speaking of which, next time we're going to talk about what happens when you do say the magic words, you invoke your right to silence and your right to counsel. And the interrogation doesn't stop. What a judge can do about it, and the one thing you must never do if they keep asking questions anyway. You'll want to hear that one. Before you ever find yourself in a room with a two-way mirror,